me co-host real quick, and I will mute.
I sure can.
Says my video is stopped by the host.
Well, we're just having all kinds of problems today.
Because probably everything was going according to plan for the first part of the morning.
Ba, 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 da, ba.
Angela, real quick, did you have any particular format? I was figuring you and I were going to banter just back and forth more, maybe talk about legal update, but also at some point, say, hey, Brian, you've done a lot of buyouts. I was going to talk a little bit about the buyout, the benefit of using, an attorney such as yourself to help with a buyout. And then also, also just talk about sometimes, and I'm not saying it's the right thing, I've done a little unorthodox where they say I can take their stuff, I can move their stuff, but check that with an attorney because I don't believe it's enforceable. And no, if they told me I couldn't go in, I'd never go, I couldn't move their stuff, I wouldn't.
Yeah.
Timing a check and all that stuff.
I think, when I give some court updates and some reminders about some things that are still operating procedures that were not in place prior to COVID, because there's still some of that happening right now, just for people to be aware and sort of what the court's doing with it if you don't do these things. And I'm sure we'll have lots of questions. We can talk about other options like you described. So I think we got plenty to talk about. No PowerPoints today. It's going to be talking heads for folks. Because at some point, making PowerPoints for the sake of making PowerPoints just doesn't make any sense.
Cool. I'm going to grab a handful of nuts. I'll be back in 30 seconds.
Okay.
So I don't get hangry.
So thank you for everybody that's jumping on. We are a little bit before noon. We'll give people a few minutes to get on as that link goes out for people to join. Today's topic is evictions and sort of the court process and what's happening now that we are roughly 8-ish months post moratorium. So I have a few updates for people about that and what we're seeing in the court system. And I think, we can expect even some more changes going forward as, things continue to evolve and change. So, one of the tenements of this last couple of years has been everything that we talk about today could be totally different and changed tomorrow or next week. And so, that's sort of continually checking and updating and making sure that the information's still good because it goes stale pretty quick. Not as quickly as say in the beginning, but we're still seeing sort of some rapid changes and things. The rules aren't staying the same constantly. So
Keeps me excited.
Kind of a moving target, which is
So one is, as everybody goes on today, one of the things I'm exciting about is I think this would be a really informational and participatory topic. So I hope you guys ask more questions, use the chat box or the Q&A so that we can make it as interactive as possible. Most of you guys know this. My name is Brian Armstrong, the CEO of Keller Williams, Vermont, as well as Strongwell Real Estate team and the Strongwell Property Management Group. And investment properties has been one of my greatest passions. It's changed my life and my family's life. I love dealing with real estate customers because oftentimes less emotional, it's more numbers based, and you get helping people really provide for their families and their future. In evictions, I think is one of the most challenging topics. Personally, we've had very few of them, and I think that's something we hopefully to share our best practices on. But I would absolutely recommend two things. As always, if you're not, join the Vermont Apartment Owners Association because it's a great advocacy group and they've helped me tremendously. There with the phone in the background. And the second thing is, if somebody tells you to go blank yourself and they owe you $1,000, don't pick up a baseball bat. They'll own the building if you do. And Angela loves these because she never knows what I'm going to say.
Yeah, it's kind of like sometimes being in court, you never really know what's going to happen, and you just kind of have to adjust and roll with it and make changes on the fly. So
Angela, one of the questions I'm dying to know,
okay.
With the backlog that was COVID, are they airlifting in extra judges to catch up with the backlog?
So, all right. So I think let's get this started. I think we're a couple minutes in, and we'll do an official start here, and then
Yeah.
I'll take up that question. So, my name is Angela Zykowski. I'm the director of the Vermont Landlords Association. We are a trade association for landlords. We cover the entire state of Vermont. I'm also a practicing attorney, and I have a separate law practice that represents landlords, primarily right now in evictions. That's sort of the hot subject matter, as we have left the eviction moratorium that was in place for 18 months here in Vermont, and have transitioned to landlords being able to refile and re-pursue eviction cases. So, Brian, I think to address your first question about backlog, here's what happened during the moratorium. The number of cases that was filed was really low. Most landlords really tried hard to work out situations with their tenants. A majority of rent payment situations were able to be cured with all of the rental assistance money that's been flowing into the state for the last 18 months or so from the federal government. And so there were a considerable number of pending eviction cases that were solely related to rent issues that were resolved, paid, and dismissed, along with sort of current cases. So there wasn't this sort of overwhelming quote unquote backlog of cases. Were there cases that were sitting there for the 18 months of moratorium? Yes. Were there new cases filed during that 18 months of moratorium that then sat till the moratorium lifted? Yes, but the number was very small. The other thing that we've seen since the lifting of the moratorium is the number of filed cases is still lower than it was pre-pandemic. So the number of new cases coming in through the door is still low compared to what it was before the pandemic. Again, I am going to attribute this to the amount of rental assistance that is currently in the state. We know from statistics that a substantial majority of the cases filed in Vermont relate to non-payment of rent and the tenant's ability to pay the rent. And with the VRAP program that's currently running, many of those cases that are just related to the tenant's ability to pay rent are being resolved through the payment of those funds. Now, what is going to happen when those funds run out, or when the tenant times out of their participation in the program, because there's caps on how long the tenants can stay in these programs? That's going to be another issue and another situation. But we haven't seen the number of cases filed that I think people were expecting, and they have been lower than normal. That being said, the court is still operating in a remote fashion for the most part. The civil courts are just starting to restart their jury trial system. So if you have a case that's a jury trial, and some landlord tenant cases can be jury trial cases, those have not restarted yet. So, or are just in the process of restarting, meaning that is one area where there is a backlog and challenges, because most of those cases are still on ice.
Well, what's interesting is I'm really caught off guard by that. I would have expected the numbers of evictions actually gone up significantly. I would agree with you with probably the reason why. And I've even talked to owners recently that either didn't think it was worth the time, or it was just too confusing. So I've been amazed at a couple of landlords haven't.
Right.
But, one of the things I was going to actually ask you about was, jury trials. Now,
Yep.
Are they truly offering them because it's their constitutional right?
They have a right under the rules in Vermont to ask for their case to be heard as a jury trial. Any civil case in the state of Vermont has the right to be heard as a jury trial. So one of the things that we've seen in the court process, so we know there's less cases being filed, or at least the last time I saw the statistics, there were less cases being filed. What has happened though is the court is still handling all of their hearings on electronic platforms. So we're still virtual. We're still having hearings on platforms like Zoom with the court, all of our witnesses, parties, and things like that. So the court can actually process less cases at a time because of this platform. So I'm seeing cases move through the system more slowly because we're limited by how many the court can hear at a time. So just for an example, in Chittenden County, they would have rent escrow days, and it was like every other Tuesday. And there would be 3 to 4 rent escrow hearings scheduled per like half-hour block. And they would just stack them in, and it would be, there's people everywhere and things going on. And, so you can imagine you can cram a huge number of rent escrow cases in a morning if you're scheduling them like that. They are now scheduling rent escrows, 1 case per 15-minute block, and in some courts, 1 case per half-hour block. Because with the electronic platform, you can't have multiple cases. It's limited by the structure of the electronic system. So scheduling and getting scheduled is premium and has been one of the challenges for some of these cases. So they move through the system more slowly. They are still moving, and tenants are still being evicted. And the courts are enforcing those notices, and they are enforcing the rules. It's just happening much more slowly.
It's still, again, I'm surprised because I would have thought with virtual, they would have actually gotten more cases done, but probably everybody with tech issues, the amount of people that are dealing with tech issues, which is a side note, is a disconcerting thing in our society. About 7 or 8 years ago, I bought a tenant out, and part of the buyout was they moved, and I kept asking, like, well, how are you doing on finding places? This is when there was not a reasonable amount, but it wasn't as tight as it was now. And finally, when he didn't have issue, couldn't find it, I was like, where are you looking? And he said, well, I get the free press every day. And I'm like, oh my God, because he didn't have internet, which is another issue that we'll necessarily deal with. And, and Angela, as we reflect back on this, right now, what do you think is probably, and I know we'll talk about buyouts later, but other than getting your tenant to agree to go out through buyout or just good conversation, what do you think the 3 most important things a landlord could do to better help themselves have a successful eviction?
Yep.
If they actually have to formally file?
Yeah, and the biggest one is always making sure your termination notice is correct. I've done hour-long, I've done half-day seminars on termination notices. People are probably tired of listening to me talk about termination notices, but the termination notice is your ticket into court. If you don't have a proper termination notice, the court does not have jurisdiction to hear your case, meaning the termination notice is what gives the court the authority to award you possession of your property. And so if there's anything wrong in that termination notice, we are seeing motions to dismiss be filed and be granted if there's problems with the termination notice. So the big one is there have been some changes to how you have to do your non-payment of rent notice, right? Non-payment of rent notices were always tricky, even before COVID, because you had to have your back rent amount in there, and it had to be just rent. Can't include other things, can't include late fees, can't include unpaid parking, can't include unpaid utilities. It can't be anything else. It has to be just rent. It has to tell the tenant they have the ability to pay to stay. And it has to have a specific termination date in it. Now, the statute in Vermont says that the tenant is entitled to at least 14 days of notice when there's a non-payment of rent situation. We have some lingering federal legislation that has not entirely gone away, or the judiciary does not believe it has gone away, which requires a substantial majority of properties to send a 30-day notice for non-payment of rent. And there's a certification that the court has required to be filed at the time you file your case saying, my notice complies with these CARES Act requirements, one of them being my notice is at least 30 days long. So right, wrong, or indifferent, that is what the court is requiring. And the fastest way to have your case hung up or thrown out is to use a non-payment notice that's not 30 days and to not attach a CARES certification when you file the case. So my recommendation is for all landlords, regardless of how your property set up or how your financing set up, is to send your non-payment notice, make it at least 30 days, and then you know you don't have any issues when you get to court.
So we're going to jump in.
Yes.
And I'm catching myself. The KW have a course called Bold, and they have a bold law, focus on the plan, not the problem. So I'm challenged by that right now because I'm focusing on the problem.
Yeah.
And is it really just to do with federally backed finance, or does it have to do with that I may have missed a small piece? Is it Section 8?
So, so I'm going to screen share for folks because I did pull up the form that is required to be, there's two forms actually. This is one of them. Hang on, yep, no, go away. I'm the host and so my thing's being weird. Okay. This is the CARES Act certification form that is required to be filed with any eviction case, Now, the judiciary changed the rules in December. So this used to only have to be filed with non-payment of rent cases. Now it has to be filed for every eviction case. So you can see there's a checkbox there that says my property's not covered. But you have to go out and do these other things like attach a copy of your mortgage, use these lookup tools to show that your property doesn't fall into one of these programs, that nobody on the property is receiving any federal subsidies or benefits, and really, when you try to navigate this system and try to navigate this level of documentation that's required, the path of least resistance is to send a 30-day notice. Because if you send the 30-day notice, you check the box that I've complied and you're off to the races.
And I'll be frank too, because when I asked the question, like, all right, how can I short the circuit this? How can I get to the good old days of 14 days?
Mm-hmm.
But it sounds like we're just better to do the 30 days. And there's nothing more aggravating, as I'm sure all our participants will agree, than somebody owes you money, they're in your property, and they're catching you on details.
Right. I've had a couple of folks who clearly have commercial mortgages. Like there's no way, just based on the type of property that it is, that there's any coverage here. And so we've proceeded under the property is not covered by CARES and attach the appropriate documentation, but you have to, it's a lot to do. So, you do have an option. But I have found for most folks trying to go find copies of their mortgages, that front page, doing these lookups, it's too burdensome versus sending a notice that's 30 days in length.
Good times.
Yes. There is also some requirements to have language in your notice for non-payment of rent, alerting tenants to the fact that there are rental assistance programs available to them to help with their payments of rent. We have updated the Landlords Association non-payment of rent forms to have that language in it. And so the current non-payment notice up on the Landlord Association website has sort of a note that we're recommending that your notice is 30 days for sort of these reasons we talked about, and also has included that language about the programs and what needs to be in there. So, you know, there've been a lot of updates and shifts since COVID has started, and some of it's Vermont based, like this CARES Act certification. This is Vermont judiciary is requiring this, but it's based on some federal rules that went into effect. And I think those federal rules have expired. And I have provided that information to the judiciary, and I cannot get them to change this form. And they've gone through a couple of drafts of like, should we do updates? What's the status of things? And I provide them with the information, and they're like, thanks, we're just going to keep doing this. So, you know, it's not because people aren't paying attention to it or trying to get it changed. It's just, this is where we are.
We have
right now.
A question. What best practices? James Unworth made a comment. If the judge even believes you own the property, hopefully we don't have too many of those. But what are the best practices? You know, what best practices do you recommend for 30-day delivery? Certified, FedEx, priority. I used to do, now I'm probably not. You know, I used to do hand delivered. Then I would copy and scan a piece of U.S. mail. I'd scan it to myself with a postage date, because I didn't want to deal with it certified. But now more and more, Dan and our Strongwell Property Management just sends it certified.
Yeah, I mean, when you get to court, that's the same standard of you have to be able to prove that the tenant received the notice and that they received the notice in adequate amount of time. So when I'm saying 30-day notice, I'm really meaning like the 38 or 40-day notice, because I'm adding some extra time to allow for delivery through the mail or by sheriff. You know, the statute says that mail is presumed to be received 3 days after it's sent. If anyone has sent anything through the US mail in the last year, you know, that's probably not true. So just, you know, be careful and be mindful and add those few extra days. It seems like a lot when you're sending the notice, but nothing's worse than having your notice float into an office like mine, and we look at it and we say it was delivered late, or the notice isn't long enough, and now you have to redo it, because you need to have that good notice to have your case go forward and go through and not have any problems. So yeah.
What about the notices that the landlord or the property management starts and then turns over to you? How do we make sure? Probably one is, I'm going to guess, you know, with humor, but seriously, be a member of the Vermont Department of Organizations, use your forms. Do they have to copy you? Do they have to do anything to make sure that you can pick that notice up and start slaying the dragon?
No, I mean, some folks occasionally will shoot me a copy and say, can you review this and make sure it's okay? I mean, there's pretty detailed instructions that we include with the notices on how to do them and how to send them out. So it, you know, I will say people use the Landlords Association notices and they come over and something wasn't done correctly and things have to get redone. And that's just unfortunately part of the process. But, you know, the folks at the association can help. I can help. Cindy can help. You know, we routinely, you know, help people with dates and how to figure out what dates to put in where. But they're pretty straightforward. The more challenging ones are the breach of lease, you know, how much detail you need for that notice. But if you're using a non-payment notice or you're using a no-cause notice, that's really just pulling out your calendar and doing some counting on the calendar to make sure you have given enough time. February always messes people up because if they're just jumping months, like, oh, I'm sending it January 15th and I have to give them 60 days, I'll make my termination date, you know, March 17th, forgetting that February only has 28 days. So we see some things, yeah, we see some things like that occasionally. So really, as silly as it sounds, like I will still do it. If I'm doing a notice for somebody, I pull out my calendar and I'm sitting there like counting out because I just want to make sure it's right.
What would be the two other most common mistakes, you know, that landlords, you know, or property managers make when beginning the eviction process?
So if it's related to non-payment of rent, a lot of times it's having other things in the number that's owed. So it's whether it's extra fees or like a return check fee or a late fee or something else. So they've added other things in the amount that they've told the tenant they have to pay. And sometimes that gets figured out when ledgers are produced or somebody starts looking at the numbers. And so that can really sort of trip people up. And the other piece is waiting too long from the termination date. So notices have a lifespan, and a case has to be started within 60 days of the termination date in the notice for that notice to still be effective. So waiting too long to then sort of start that case can create problems, and you have to start again if you miss that 60-day window. So.
And I might add to that, and correct me if you disagree with me, and I'm sure you will. You know, when I was more hands-on in our units, and now again, Dan does a great job for us. Sometimes the old adage, the road to hell is paved with good intentions. You know, so I would talk with a tenant. You could tell they were sincere and not lying to you about their intentions. Now, their abilities to match with their intentions may not have always been there. So I found if I didn't, you know, so I found over the years that when I was nice, it caused me to just get backlog. So I suggest, and you tell me this is wrong, probably need to do what you do for one, do for all, so that you're not accused of discrimination. You happen to give a non-protected class an extra few days of delaying rent before you send out notices. Now, the other thing that personally I would say to tenants is, and excuse the analogy, this eviction notice is just like a bullet in the chamber. Now, if you're true, like most of the tenants I know, on your intentions to get caught up, this goes away. All you have to do is get paid and it goes away. But unfortunately, if you're like most people I know in these situations, you're well-intended, but your abilities don't match your intentions.
Right.
And if I just don't issue this, then I'm just going to delay, and that's not fair to my family.
Right.
So,
Well, and the thing to keep in mind is with all of the VRAP money and the federal money that's in the state right now, at any point, if your case is for non-payment of rent, at any point in that process, the tenant can access the VRAP money. And if there's a pending court case, there's also the ability of the tenant to access money if they've applied into the program to get filing fees, any sheriff's fees you've incurred, and if your lease allows you for the collection of attorney's fees can also be added. So there's ability to get paid and be made whole in non-payment of rent cases at a level that we have never seen here in Vermont before. And so that hesitation to like, I don't want to spend the money to start this case because my tenant is going to pay. I think one takeaway might be have that alleviated, because if your tenant applies into the program and you've started the case, you have the ability to recoup those fees now where you didn't before. So if you're waiting because your tenant's maybe going to pay you, you may not want to do that, because if they do get into that program, you can get your eviction fees paid for. But if they don't, then you haven't wasted the time waiting for them to get into the program.
yeah, that's, you know, a really good reason. I would say it's funny because, yeah, I quote too much. One of my favorite quotes is, there's always flowers for those who wish to see them. And it sounds like in the flowers, that was landlords really taking it on the chin during COVID. One of those flowers was there's more rental assistance than ever before.
Right.
If you pay for it.
And the challenge is, as many of you have probably already learned, is this particular program, rental assistance program, requires the cooperation of the tenant. The tenant has to put in application. The tenant has to put in income information. They have to play along and play ball. And so if they're just out of the gate telling you, I'm not gonna do it, then you have to proceed to sort of stop that financial loss from happening. But through the course of that eviction, there's going to be outreach from Vermont Legal Aid, from different tenant advocacy groups that are trying to get those tenants to the table to get them to apply in for these funds. So, you know, sometimes if you have the tenant that's just not being responsive, not applying into the program, sometimes the best and easiest way to get them into the program is to actually kick off that suit, because then other folks are reaching out. And if they don't apply and your eviction just moves forward and they get evicted for not paying the rent. So I feel like, weirdly enough right now, I think landlords sometimes, particularly in rent situations, get more assistance and have more help with getting tenants into the program if they file that eviction with the court, which is sort of the backwards of what it should be. But that is also what's happening now. We know lots of times there's other issues there, and maybe you don't want that tenant to be there. If that's true, you need to also be sending a second notice, whether it's for breach, whether it's for no cause, whether it's for some other reason. Because if you just send a notice for non-payment of rent, your tenant can stop that case by having the rent paid.
That's a great point. And that means you might be stacking them with reasons, which is also can be a good visual effect, because I think it goes into another thing. And James Unsworth, great to have you on again. I hope all's going well, especially the little one. But James made a comment. I was about to add, if they play ball. James has already had 2 that haven't played ball. And James, you're very eloquent and well-spoken. But I'd encourage everybody, and this may or may not be time to segue into, and we can do it in certainly a few minutes, if not, the move out discussion.
Right. But let me go back to that, because I think what people need to understand is, prior to COVID, I would tell landlords, please make sure you plan on a minimum of 3 to 4 months for an eviction from the date we start the case, right? And that was probably a little extreme, because I don't want to tell people plan on 2 to 3 months at a minimum and then have it go 6 months and then people get really cranky with you. So I would tell people plan on a minimum of 3 to 4 months. I would say right now, with what we're seeing, plan on a minimum of 4 to 6 months from the time you file the case. So you have to ask yourself, if you're going to give that tenant another month to come up with payments before you file that eviction, can you then carry that property for another 4 to 6 months? And if your tenant files for a jury trial, we can ask for rent escrow and some of these other things to sort of get some rent started. But you're looking at potentially a significant amount of time from the start of the case to the end of the case, and it's longer than it was before, and it was long before.
And that actually brings up to another point. And James, you're very well spoken, but I think how you talk with people, how you address with these people, is a good necessarily part of it. And with the jury, the jury trial is actually terrifying. I would also encourage anybody that's starting to have a tenant who's not making rent, ask yourself their actual ability to apply for this paperwork. Amount of stuff that they have to upload. Will they, possibly make an introduction, COEVE, possibly offer to have them come to your office, or even go to their house with a laptop. If they got to scan documents, that might not work, but maybe they can give you documents to take with them, because again, we are seeing, unfortunately, a more disparate difference between the haves and the have not. And a lot of them don't have scanners, don't have computers, don't have to do it if they're older and of a lesser economic means.
If you yourself as a landlord have a smartphone, you can go out and get the app called Genius Scan. I believe it's a free app, or if it's not free, it's not very much, maybe 99 cents or $1.99. And Genius Scan will allow you to use your camera to scan any document in as a PDF. And it's actually pretty good. Some of the older camera scanners were a little bit like wonky, and your paper would be like all wavy and you could barely read it. This one's actually really good. And so, if you were on site with a tenant and trying to help them navigate this, and you needed to scan in a document, that's a really easy way to do it, to get it into a PDF format.
Yeah, and James, again, appreciate the comments. Folks, the more you comment or question, the better off we can make these. So please, raise questions. But James made another comment. Fortunate thing, their tenant was head in the sand, which we've definitely seen those as well. Manager even filled out the paperwork. So it is going to be some without a doubt. And, the other things that come to mind too, and Angela, it seems like you did a great job representing both of them. This goes back a little ways. But I would encourage you as landlords, property owners, or if you're agents helping buyers, buy properties, forward communication. One of the reasons why I think Strongwill had very low number of evictions, we started as soon as the shutdown happened, started beating a drum. Please talk with us if you're having problems. Here's where you can go for research. And I'm not saying this is going to solve everything, but they saw us two different things. They saw a forward amount of, communication saying we care. And then the second thing, we got them to talk to us before it was too late. And we moved some tenants to bi-weekly to help, which is not ideal.
Right.
But it's better than necessarily going to, which will segue into at some point, the buyouts.
And I think the other challenge that we have seen is a ratcheting up and an exacerbation of behavior type issues. So you may have a rent related issue, but then on top of it, there's also some behavior stuff, whether it's noise, whether it's drugs, whether it's punching holes, having, sort of mental crisis type situations happening. I've definitely seen an uptick in those, not only in frequency, but also in just the type of behavior and the sort of violence is maybe the wrong word, because it implies that people are, hurting other people, but really sometimes they're just hurting the building and themselves and causing, but just an increase in the level of behavior and also the frequency in which we're seeing it. And I think part of it is related to circumstances and stress and people not being able to get treatment. But that is also happening. And for me, that's even more concerning because it's indicative of a different issue.
It's interesting with that issue. I think there's a couple things that come to mind. One is I'm honored to be in business with about 200 agents, and we've seen more challenges in clients and agents. So I'm sure it's happening in tenants as well. And we're actually seeing more than people are coming out of the woodwork. We're seeing actually they're more challenged during it. So I wouldn't hesitate if you've got somebody who thinks got mental health issues, behavioral issues, trying to bring in, advocates for a couple different reasons. One is, my mama raised me right. It's the right thing to do. Secondly, I think they may be able to help move this process along. Thirdly, maybe. Thirdly, I also think, I think you may be seen as somebody who's trying to help while defend your rights. I.e., one time I had an issue with, a woman that had to be physically challenged, nothing to do with her physically challenged. I purposely brought in code, brought in the state preemptively, because I had a sense. She actually took Radio Shack and one of the carriers to federal court on a handwritten deposition that they were stealing her contacts. So when that happened, I knew I was in for a long ride.
Yeah.
And so by bringing in the state, I was preemptive to making sure, first, the building met ADA or was ADA. Two is I was doing anything reasonable, and that I positioned myself as a caring landlord.
Right.
Angela, quick question, maybe, I don't think it's off topic, but I think it'll help people, and it's not just Burlington, because if it goes through, it's going to be a wave across the state. Yeah. Where's Just Cause at?
So Just Cause made it out of the House right before the legislature broke for town meeting week. So legislature never meets the week of town meeting day. So right before that happened, the House voted it out. There were a few changes that have been made to the bill. One of the biggest changes that the House made to the bill was to require that the probationary period that was noted in the ordinance or the proposal be at least 1 year. Meaning that Just Cause wouldn't be able to go into effect until the end of the first year of tenancy. So the legislature put that in as, again, one of sort of these guardrails. And they also removed the exemption for smaller landlords. So now the Just Cause would actually apply to all properties in Burlington instead of just ones with 3 or more units. So that was sort of an interesting change that happened. And I feel like there was a third change that I'm totally blanking on. The big one was the 1 year probationary period before Just Cause went into effect. charter as drafted by city council and voted on by the voters just made note that there would be a probationary period without defining further what that was. And so the legislature said it has to be at least a year. So
that's a little positive, but my concern is another example of road the hell is paved with good intention, because I bet you'll see a lot of small landlords with borderline tenants just moving out every year.
Yep. Yeah, it's not that's not necessarily going to help with what the ordinance's goal is for housing stability. That's what the intent of the ordinance is. I think it's misplaced completely. And I think there's a lot of unintended consequences that folks aren't considering and the impacts that this is going to have. So that bill is now over on the Senate side in the Senate Government Operations Committee. And I don't believe it's been listed on their calendar yet, but that doesn't, I would expect it to be taken up at any time.
And I would challenge anybody on this webinar, especially if you got property management clients, get them to advocate, get them to advocate. This is a very, very domino effect type of law. But circling back to, core evictions, maybe it's a good time now to talk about buyouts. Mm-hmm. What are the do's and don'ts of buyouts? And you've sent some people to me to talk about, so I can talk about how we approach it and why we've had a lot of success. Doesn't mean we're having more success or less, but there's more to it than just the agreement. What are your thoughts on buyouts?
I think they're fine. If you can get the tenant to agree with it, that's always part of the challenge. I do think they, to some extent, have limited enforceability with a court. So it relies on both parties following through with what they said they are going to do, right? Because usually it involves the tenant leaving, and in exchange for the tenant leaving, the landlord maybe makes a payment or returns a deposit or waives back rent, or, there's some sort of benefit given to the tenant for voluntarily vacating. And so you can have the agreement if the tenant doesn't leave. It probably is not likely you can then take that buyout agreement and go to court and say, I want a writ of possession because they didn't leave.
Which probably goes to cement earlier points. Start the process. My 2 cents would be, I don't care whether they agree to a buyout or not. Make sure you get your 30-day notice going. So again, bullets in the chamber, in the chamber.
Right. I mean, I will say, I believe that the statute would support the enforcement of an agreement like that as a notification by the tenant of their intent to vacate. And if you read the statute, that should be something that's enforceable by the courts, including the issuance of a writ of possession. The problem is landlords and the way this model works don't want to be the test case. They don't want to try it, because if it doesn't work, you have to send a notice, and you have to start again, and you're already months behind, right? So generally when I'm giving advice or when I'm advising landlords, we're looking at what is the path that's going to get us there the quickest, with the least amount of legal motions or legal issues, and that is the most streamlined to the end goal, which is getting a writ of possession.
Yeah. My father used to say one of the happiest days in a landlord's life.
Right. And so, unique legal theories and unique ways of doing things. And, while those are fun to talk about, most landlords don't want to be the one that's like, oh, sure, I'll try that and see if it works. And I get it. Like, I wouldn't want to with my investment either.
And Angela, I think one time when you and I were talking about it, you recommended having you drafted or, witnessed. So at least there was more, if it went to court and it was going to be tested and somebody wanted to test those statutes, that it was more compliant and able to be recognized by the court, and the chance that it would be.
Yeah,
because just a scribble out.
Right. And sometimes, depending on when the move out date is, we'll do like a 2-step, like, we're signing this agreement and the tenant's also acknowledging that the landlord has given me a termination date termination notice of the same date for this date, and if I don't move out, I know I may be evicted. Like, so like sometimes we're doing both. So there's a little more like coordination, just to keep, again, as many options open to the landlord and to be ready if the tenant doesn't go.
And, you know, folks, what I'd suggest too is we possibly even go deeper in this conversation. First and foremost, never give the money up front. Never,
God,
ever,
no,
ever.
no.
Never give the money up front.
No.
Well, but Brian, I need the money to put a deposit down. I'm not going to tell you to pay another landlord, but I think once or twice I said to him, if I hear from another landlord, I'll consider giving a certain amount to the landlord. I think I might have done it once. The other thing you can check is a litmus test. Are they honoring the rent out agreement? And tell them this, like, hey, you know, Angela, if I'm hearing from landlords, I'll tell the Vermont Apartment Owner Association not to take you to court because we're hearing from them. But if I'm not hearing from landlords, that means you're not following through on this agreement. And
Well,
so it's some litmus tests along the way.
And here's the other thing right now to keep in mind when you're talking about buyout agreements or tenants moving, there is a component of VRAP that is called money to move. And so a tenant can actually get money for first, last, security, moving expenses to go to a new place through VRAP. They have to have an application in and they have to be approved, but there's funding there for them to help them make that transition.
That's good info. That's huge. So I'm going to quote somebody I don't have a lot of respect for, rest their soul, Donald Rumsfeld. And we don't need to go into politics. Well, I don't have a lot of respect for the man, but I'm also started doing it. One of my favorite quotes from was, "I'll neither confirm nor deny." So I'll neither confirm nor deny that when I used to draft letters, I knew there was a small chance that they could be used in court. But I would have it state, you know, I blank Smith, Brian Armstrong or Strongwell Property, blank dollars as of this signing. I recognize that, you know, I'm behind X number of months, that I violated the lease as following. And upon blank date at blank time, Brian Armstrong will compensate me for X. And if I'm not out by this time, he has authority to change the locks, remove the belongings, and all that stuff. Now, the reason why I'll neither confirm or deny with humor being recorded, too, is there's some questions about the legality. And I'll tell anybody right now, if you do a buyout and they agree to that, and they tell you at 3 o'clock on the day of you should be able to change locks, don't go in and change the locks if they're in there. And if they're telling you they're not moved out, double check with Angela very carefully on what defines abandoned property.
Right, because I'm probably going to tell you if you change the locks and the tenant's still there, it's an illegal eviction.
And then police officers will, I think, what, $600 fine if they don't help you get moved back in or move the tenant back in.
Right. I mean, it's just messy and makes any action to try to evict the tenant just that much more complicated and challenging.
Yeah. Now, what I will say is when they wrote all those things out and they signed their name to it, there was a certain amount of recognition to them that they were in fact guilty of X, that this train is leaving the station. And here's a really important piece. You guys know this, and I recognize a lot of the names on today. Great to see you, and thanks for coming. If you deal with it, the emotion that you want to say, you owe me blank, so you better get your blank, blank, blank out. That conversation's not going to work. One of my favorite authors is Chris Voss, former international lead hostage negotiator for the FBI. Great book, Never Split the Difference. And a second book, The Light Switch, also by a former FBI agent, talks about the importance that we all have to feel that we're in control. So my big recommendation on the buyout is do what's called an accusation audit. And Angela, I'm sorry, your name's just going to be the one I use because, well, you're right next to me on Zoom. Hey, Angela, I get it. COVID, the courts are backed up. You might even request a jury trial. This could drag out for months. You're absolutely right. The cards are in your favor. You're also upset you're not able to pay rent. I'm sure you intended to do. And, you know, you're not set. We haven't done X in the building. And so then basically the tactic there is to go through everything they're going to say, everything they're going to think that they can overcome you in this situation. Clear it all out, acknowledge the accuracy, acknowledge the validity. And then with humor, for those who know me, one of the most tough things is a moment of tactical silence. Now, that key moment is if they start interrupting, you can't do that, you're going to take me forever, you haven't done the accusation audit well enough, and you have to repeat. Then ask a thought-provoking question. And this is where our individual desires, for control come in. And you can't answer it. You know the answer. And you want to tell them that, but you can't. So Angela, you have to ask yourself, are you going to be in here forever? And if you're going to go, would you rather have some control on how you go? Or would you rather wait for the sheriff to show up when you have 45 minutes? It's your choice. But I got to tell you, I've been there when the sheriff shows up. It's not a lot of fun. So what do you think you want to do? You want to try to fight the fight, or you want to have some control on how you move out? That moment, I usually see like a sort of, you can see like a wash of a knowledge bomb is going over somebody's head. And they start to realize, yeah, I could fight the good fight. Now also ask them, and would you rather live with the pressure of not knowing when the sheriff's going to come up, not knowing when the next court date is, having to get time off for work to go to court? Or would you rather just work something out? Which is contrary to me wanting to send Louie and Vinny over, which is really what people want to do, but you can't do because the tenant will own the building. And you'll be in hard time in Leavenworth. So if anybody on the thing, feel free to reach out. I'm happy to practice with you. I'm not going to say it's going to work every time, but we've had in our own personal buildings, I think we've had 0 evictions during COVID out of 28, 30 units out of our clients, give or take hundreds. We inherited a couple. We have had a couple people refuse buyouts, but I would say probably we have less than a 1% eviction rate because of not only how we run the buildings, but the conversations that we practice. And that's a key thing, practice like this.
Right. Right. And, it's always surprised me how just sort of treating the tenant with a little bit of respect when I'm talking to them, if we're in court or otherwise, will get a huge amount of traction. I had a court hearing a couple of days ago, and I asked the tenant, "How are you?" And she said, I'm fine. Thank you very much for asking. And it made me pause because it just seems so normal and natural for me to ask somebody that, even if they're in sort of an adversarial position to me in court. And it got me thinking, like, how many interactions has she had with people where it just was like, you couldn't even have that quick, pleasantry before you sort of got into the nuts and bolts. The other thing that I'm always surprised at is when I ask a tenant, how much time do you think that you would need? I'm always surprised by the answer because it's usually not as much as I'm expecting or the landlord's expecting. Sometimes it is super unreasonable and it's, way down the road and it's not going to work for anybody. But I'm generally have just learned that sometimes asking that question, we can sort of get a sense of, are we talking about the same thing here? And many times we are talking about the general time frame that works for everybody by just simply asking them, how much do you need? Because then again, it's that approach with Brian, you've put them back into control of a situation that they feel completely out of control in.
The other great question I would ask is, what is your plan B?
Right. I use that one a lot.
Yeah. If your goal is to fight this as long as you can in court, what is either A, your plan B if it doesn't work, or when that comes to an end?
Right.
And, and sometimes maybe even seed it. Maybe you need to check with friends. Maybe you need to go to CBOE, maybe talk to VRAP, but ask that thought-provoking question. What is your plan B?
Right.
And a side note, I'd recommend before you have those conversations, a zoom in and zoom out tactic. What I mean by zoom out, how quickly could you re-rent your unit? What could you do with the rent value? How much cash flow is it costing you? And you just heard today, I used to say 3 to 4 months. I'm hearing 6 months now on average for evictions if they don't request a jury trial.
Mm-hmm.
You can sure legal aid, who's got its place in our society, and there's good reasons why they're there, is going to mention the trial. is then take an analyze of what it's going to really cost you. Because the first time I did a buyout, I wanted to puke. I felt that that little kid in me that believed in the world of right and wrong just died.
Yeah.
But then I got a 2.5-year tenant in, raised the rent $300 or $400, got that tenant bought out in 2 weeks. It was one of the best financial decisions I've ever made,
Right.
even though it felt like the wrong decision.
Right. And I mean, the reports that I'm hearing about the rental market is finding a replacement tenant is not the problem right now.
Shooting fish in a barrel.
It's wading through the overwhelming number of applications and requests that come in the door when you have a unit open that is presenting challenges for landlords and property managers. So the ability to re-rent a unit is not, should be sort of way down on the totem pole or way down on the pole when you're thinking about reasons to do a buyout or not to do a buyout.
Yeah, no, I think it's absolutely excellent. We've actually got a question, Sue Wiley, and just Sue Wiley from Essex. I hope all is well. I think we went to high school together. Is chronic late payment a breach of lease, and how does the court treat it? And before you answer that, Angela, I would add, what defines a late payment? Is it 10 days? Is it 5? Is it 2? Please.
It is a breach. In my experience is the particular judge sitting in Chittenden County would find it to be an enforceable breach and would allow an eviction for that. I would say my sense is the judge in Washington County may not. He has a little different viewpoint of some of these things and a little different approach. So it's going to depend on where you are. And if that's the only reason, I would say use that breach of lease notice in conjunction with, say, a no cause notice at the end of the lease term. So you have some certainty. If there's more breaches, I would include everything, right? So I generally don't recommend sending a breach notice for only one issue, unless that's the only issue there is. And generally that's not the case. If somebody's not following the lease in one regard, there's usually multiple reasons that they're breaking the lease or not following the rules. So as many reasons as possible is generally the best approach.
Okay, folks, we have 5 or 6 minutes left. Any questions that we can answer to bring more value to you would be greatly appreciated. You know, and why, you know, we're waiting for any additional questions. Angela, what comes to mind is maybe something we haven't covered on the topic of agenda or eviction that we should have covered?
I think just having some patience for the process. It is moving more slowly. And you know, your lawyer can only do so much. We don't have control over the court's schedule. We don't have control over how the court schedules these, when they schedule. We have some ability to, you know, pick up the phone and ask the clerk, hey, what's the status and is this going to get in for a hearing? But ultimately it's the court, and it is frustrating to just be waiting for the court to do something. So I think, you know, just if you're going in and you understand that the process is going to take some time and it's going to be aggravating and there's going to just feel like there's long stretches where nothing's happening, that is sort of the reality right now.
You know, Jonathan Brigatti, one is thanks for attending, made a comment. I have 2 tenants who met the requirements for VRAP, but they just found the application too arduous. I only realized after sitting down with them and asking them if they needed help. Both instances worked out. So Jonathan, I congratulate you, because I think the other thing is, and Angela, you touched on it with just asking how the person was doing.
Right.
Just, you know, some of these people are great people, some of them not so much, but I would argue 89% of them are good people. They just are in tough economic situations. And some of them may be too proud to admit that. So if you're asking a question, what could I do to help you with the VRAP process? If we were to get together, I would stop by, would that be of helpful? It'll do 2 things. It'll get you that much closer to the VRAP money, maybe 3 things, and or eviction. And it'll start to make you look human because you're treating them as human as opposed to get the blank out of my house. You know,
Landlording is a tough business. And you're human and you have human reactions and human emotions, and you are treated poorly. You can be treated poorly by tenants. You can be treated poorly by the system. You can be treated poorly by tenant advocates. And it's hard to always be taking the high road, to be not responding, not reacting, to just taking the criticism or the pushback and having it, sort of roll off your back. But in the long run, doing that and keeping your cool and just, acknowledging the tenant and trying to help them work through whatever challenge they're having has some long-term benefits to you when you're dealing with difficult people. It's, I've had days where I've had received tenant communications and have had to walk away from my computer or my phone or whatever, and just take a couple of deep breaths and then, come back to it. And sometimes you just have to do that because you're not going to solve or create paths forward by reacting immediately and reacting negatively, as hard as it is.
and it can be really hard sometimes.
Oh,
Yeah. With humor, I really appreciate everybody's time today. Where I mentioned the 89%, there's a book, Freakonomics, that a gentleman actually left the defense industry in Baltimore, Maryland, and then delivered bagels on the honor system, tracked how many bagels were paid for over 3.5 years. 89% of the bagels were paid for. Yeah. So I do believe out there, we've got some great residents. 89% are well-intended people, but they may be in a different economic class, different aptitude to technology, stuff like that. And so, as hippy-dippy as this may sound, treating them like humans, treating them respectfully, having non-emotional conversations, even if your emotions are, boiling, will help you get there that much more quickly. And any other final thoughts, questions, or comments from you, Angela?
Nope. I think, take a deep breath. This too shall hopefully pass. And, the rental assistance money is here. And we're probably going to phase out of one set and start phasing into a second set, which will actually run longer. It'll give tenants a few more months of benefit, and the program end date won't be for another couple of years. So, this system of having some assistance for tenants is going to be around for quite a while. I worry when it ends because I'm not sure that everybody's making plans for how that's going to look. And that could be another point at which we see some issues and some increases in evictions as people now haven't made plans to be able to pay their rent and don't have that assistance to help them. But that's the next wave, I think. But, for now, if it's a current problem and it's a rent related problem, there is money out there. And hopefully we've given you some tools and advice to help, navigate that with your tenant.
Absolutely. One final thought too, I guess two or three final thoughts. One is, I believe Fair Housing Month is next month.
Next month. Yep. So we'll be doing a fair housing seminar of some sort next month.
Yeah, absolutely. Something we should all be there to be better members of the community. The other thing I would also challenge you guys is your eviction mitigation efforts begin at the application. Remember, there's questions about the validity or accuracy of the information that's shared or not shared between Vermont court systems and credit bureaus. So do thorough court searches, Google, Facebook, and if you don't have a system, either build one or hire a property manager, just because if you're dealing with something more than 3 times, you've got to have a system, especially coming up with Fair Housing Month.
Yep. Brian, and if all else fails, the landlord tenant mediation program is still running. And so that program pays for a professional mediator to help landlords and tenants work through disputes or issues. So, for the person who asked about the late payments of rent, there's nothing to say that you couldn't ask a tenant to do a mediation over that. So it can be stressed to them how important it is for them to pay the rent on time. Right. So there are other resources out there right now that have never been available before to landlords and tenants.
With that being said, it's 101. Angela, Vermont Landlords and Apartment Owners Association, Brian Armstrong, Strongwell Property Management, Strongwell Real Estate Team at KW. Folks, thank you very much. Get out there, do some great value, be kind to your tenants. And my guess is we'll see less evictions, less challenges.
Yep.
Not to imply you weren't kind to your tenants, but hey, thank you very much, everybody. Angela, thank you for all that
Thank
you're
you.
doing for us.
Thank you. See everybody next month.
Take care.